So in this part of the closing statement by Hudgells, the solicitors representing many of the convicted sub-postmasters, focus on what I have previously described as slapdash processes by the Post Office with regards to prosecutions. And they do make the conclusion, which we can see how they've got to, and he references several documents, that they reversed the burden of proof on sub-postmasters so that they were guilty until proven innocent, and to compound that even further, denied them access to the data required to mount a defence against the allegations that were being laid at their door by the Post Office. Let's jump into the inquiry.
Moving on from audit, another factor which created the conditions for this miscarriage of justice was that the Horizon contract and policy requirements agreed by the Post Office and Fujitsu treated the prosecutorial function of the Post Office as an afterthought. Policies and practices across both companies for the role which they each were to play in the criminalisation of hundreds of men and women of previously good character were neglected, ill-conceived, or disrespectful of the law. There was evidence of cutting and pasting, including possibly from pre-Horizon material, without thought being given to any known bugs, errors, and defects. Prosecution support had to begin work under a without prejudice agreement, pending further negotiation. The first written prosecution support policy appears only in November 2002, and we do not dwell on the appalling racist language in the now notorious Identification Codes document. This was most recently circulated in 2013, when many agreed it would have been read. There was no evidence of any challenge to its substance at any point in its use by Post Office. And last but not least, among the factors which create the conditions for this miscarriage of justice, is that contractual arrangements and policies were consistently read, rightly or wrongly, to promote the benefit of the business interests of Post Office and or Fujitsu, and to the detriment of postmasters. Echoing arguments before Mr. Justice Fraser, the inquiry heard evidence on corporate misreading of the contractual obligations owed by postmasters for losses, equating them to strict liability for everything that went wrong. Witnesses repeatedly adopted the essential position that postmasters were, quote, responsible for all losses, unquote, and seemingly required to make good any discrepancy, whether attributable to negligence, error, or fraud. This dangerous misreading of the legal terms on which the Post Office network operated, alongside the default perception amongst Post Office staff that any discrepancy was a user problem, as we've already referred to, sir, perhaps reinforced the erroneous impression that any flaw in the system must be human. The Post Office, without foundation, routinely reversed the burden of proof in requiring postmasters to disprove their responsibility for discrepancies. As Mr. Furlink said on the 4th of July, quote, so the auditor would find the discrepancy if there was one, and then there could be a number of reasons why there was a discrepancy. The sub-postmaster would be expected to make good unless they could identify the reason why. The onus in this policy was upon sub-postmasters to prove something that they could not prove or probably could not prove, it was conceded. Witnesses repeatedly accepted that proof of a fault in Horizon would be an unfair and even impossible task to set for postmasters with limited access to the data behind the counter held by Post Office and Fujitsu. This approach was inconsistent with any ordinary contractual construction and an obscene reversal of the presumption of innocence. Then, looking at Post Office policies on investigation and prosecution, they repeatedly stressed the significance of the interests of the business and the recovery of losses, to which we return later. Just one example, which was from the Security Operations Team's Compliance Guide to the Preparation and Layout of Investigation Red Label Case Files, POL 3038452, and page 13 of that document. It read, significant failures that may affect the successful likelihood of any criminal action and or cause significant damage to the business must be confined solely to the confidential offender report. Care must be exercised when including failures within the disciplinary report, as obviously this is disclosed to the suspect and may have ramifications on both the criminal elements of the inquiry, as well as being potentially damaging to the reputation or security of the business. Some witnesses appeared to accept that this was antithetical to the disclosure duties in prosecution. A document ought to be disclosed precisely because it is considered to impact upon either the prosecution or defence case. Another example is found in the Memorandum of Understanding on joint investigation reached between the Royal Mail Group and Post Office post-separation, and this was agreed in January 2012. At paragraph 2.4 of POL 20105-098, it reads under Prosecution Decision 2.4, cases leading to an interview under caution will ordinarily be reported to the criminal law team, acting on behalf of the organisation which has suffered the loss and against which the offences have been committed, for advice on the sufficiency of evidence and the usual public and business interest considerations. There may be exceptions to this where the lead business is the more appropriate choice, and this will normally be at the discretion of the appropriate legal team and the Royal Mail Head of Investigations and Post Office Limited Senior Security Manager, Security Operations. The issue of business interest in prosecution decision-making was addressed squarely by Duncan Atkinson, King's Counsel, in his evidence. He said, perhaps with a degree of understatement, quote, "There was also, in the material I saw, references to a series of factors that it was considered relevant to a prosecution, which included the best interests of the business and the integrity of the mail, as opposed to the much more nuanced and detailed set of criteria that would or should be applied to a prosecution decision by reference, for example, to the code." And that was on the 5th of October 2023 at page 56. And the inquiry may consider whether this focus on business interests reflected or fostered a culture which degraded the administration of justice, objectified and diminished the subject of the investigation, and encouraged instead a focus first on the bottom line. And we return to this in our third and final main submission. Any proposition that problematic policies were ironed out in training or practice notes and judged in the light of the evidence on the case studies identified by the inquiry is simply unsustainable. At each stage, there were clear flaws which, whether by design or practice, substantially disadvantaged the postmaster. The inquiry also has the evidence of Mr. Atkinson that in policy and in practice, the Post Office skipped over core steps and ignored legal obligations fundamental to the duties of a responsible prosecutor. We do not revisit his detailed conclusions, but highlight particular faults in investigation and prosecution on which the inquiry may wish to draw, and we hope these may in fact echo the conclusions of Mr. Atkinson and the experience of many sub-postmasters in evidence.
Despite the issues identified here by Hudgells, representing the sub-postmasters here with the integrity of the data from Horizon, this was further compounded by the fact that critical audit data was neither understood by the Post Office, nor was it provided to sub-postmasters to allow them to properly defend themselves in cases where frankly it sounds like they standed no chance whatsoever. The system has massively let sub-postmasters down here. That is clear, and the interests of two organisations, one privately owned, one publicly owned, have been put ahead, according to the evidence and statements from witnesses in Phase 4, above truth, justice and the interests of the sub-postmasters at the heart of this scandal.